Good evening, I'm Taras, First Nation status Aboriginal. I'm here to do a feedback with regards to Cape High Court case number 19018/18, Aboriginal versus the state. In this case, we are challenging the government as Aboriginal people to take our rightful place, our true identity, claim our Aboriginal title, and we want all our wealth, mineral, marine and natural, and this land is our land. We have inherited from our forefathers and we are borrowing it from our children. We can no longer sit back and have invaders dictate to us and suppress, dispossess and disenfranchise us. Today what happened at court was we had a court date for today, Wednesday the 4th of September 2019. Yesterday afternoon we got a message to say that the case will not be heard today. We went straight to court from the airport. We went to investigate what is the matter. The first matter was that they could not find a judge. Then they could not allocate a judge due to the fact that the file is too thick. That file has been there for a year now, so that was no excuse. The second reason that they came up with when they couldn't get away with the first one is that the practice notes was not attached to the file, which was not true. The opposing attorney has sent in the practice notes on Friday morning with a messenger, and she had a stamped sheet to prove that it was sent. Sunday, our practice notes were emailed. Monday morning, they acknowledged that they have received the practice notes. So the second excuse was also unacceptable. This morning, we came there and they said because of technicalities, they could not appoint a judge. We said that is not on. We had people coming from all over South Africa and Namibia to come and support this case. The reason being is that this country is not a country anymore. Our country has been sold as a business entity illegally and inhumanely. So we are registered on the stock exchange. Our land, our soil in our country is registered on the New York Stock Exchange as a business entity. So we as the Aboriginal people that has been disempowered, disowned and disenfranchised for the past 400 years is saying no more. The reason why people came all the way to support this case is so that they can tell the corporation, the government, that we are here, we are alive, we are standing here with our body and with our souls and in our spirit and with our flesh, and we are claiming who we truly are, because we are telling the system no longer will you do whatever you please, come into our country, take our wealth, do whatever you please, and then we must just sit back. So clearly this case not getting into court today is a willful, deliberate attempt to render us powerless once again, based on technicalities that is fictitious. Everything they said we had to do and what was required from us, we did. And hence we are saying this is a willful, deliberate, political attempt to dispossess us.
Hi, my name is Black Nguni. I just want to give you a brief history about what happened with the anti-apartheid and the ANC that took over from 1994. The anti-apartheid wasn't anti-apartheid, it was orchestrated, manipulated, and it was actually a takeover of South Africa to certain people, especially the British. And then in 1998, Mandela sold our country over to them, and that's why it became a corporation, actually a business entity. Now, we want to get ourselves off the corporation. That's one. Number two, we want our Aboriginal title, which means that people that own, or the owners of South Africa before colonialism. And we have got the Aboriginal title with the Reichersveld court case, and we already have our colored identity scrapped in 1991 by de Klerk, and even with the Reichersveld we got it back again. So now this court knows that we as Aboriginal, we came together. We were coming together today on the 4th of September, as Ras has spoken or said to y'all, that we're coming for the court case, which was already done last year already. So now, when I came with the plane yesterday now to come for the court case about 12:30 yesterday, then I get the message to say that there is no judge that was formed or found for this court case. And then I came here to the court to come and find out, and I found out that they had made a fault, or maybe misled about a file, that they didn't take certain places. Now they're trying to make it that it's our fault. It's not our fault. They don't want to admit that they had faulted. So they're trying to put the blame on me. And Taras was personally here last week. She is witness. That is why the two of us are talking, because she's in Cape Town and I'm in Durban. She's been doing everything over here in Cape Town, so she knows exactly what she's done. And they can't say that she didn't bring it in, because at first she did try and to deny that. So Taras said, no, I brought it personally to you. So there's a lot of stories that is going on. People came from around the country, the Aboriginal people, and now to get this disappointment. People came here with, I mean, a lot of people that didn't even have money. They took their last pennies to come here. And this is what this government does to our people. And it's not only our people, they do it to people that want to get their rights, and then we don't have the privilege or the right to go and claim our rights in any court, because it's not the first time that it's happened. Many of our leaders have taken a case to the court, and they find a loophole to make sure that we don't get our court case. So now tomorrow we will be sitting with the judge president, and we're hoping that we do get a case very, very soon. And we're just making this media statement that it's not our fault, it is the court's fault, because of their technicality, and they did not communicate with each other. Thank you.
We need to understand that the laws that is currently governing this land, our Aboriginal land, our soil, this is not the law of Aboriginal law, the law of nature. This is the law of the sea. When the settlers first came here, they came by ship. And because they came by ship, when they came onto the land, they brought the law of the sea onto the land. Okay? So they've been using that law since they set foot here. After they raped our foremothers, murdered our forefathers, took away, separated the children from the parents in that. They brought that law onto the land, and they've been imposing that law ever since. Every day, every week, they create new laws, bylaws, bills, and policies. What this court and this system is doing, they are refusing to acknowledge that they found all of us here, and that the laws do not apply to us. So the law of the sea is not the law of man, the Aboriginal law, the law of nature. And for 400 years we've kept quiet, we've done everything that they expected us to do. Every time they find a technicality. Today in our communities, murderers and rapists are walking free. They are set free by the same system and the same law, this legal system that gets them off on technicalities. They are walking around. In other words, the 10 stages of genocide perpetuate, and this is what this system does. It perpetuates genocide on the Aboriginal people. So as of today, even though we did not get in the court hearing as per se, we should have. We sat down with Judge Nathan Erasmus, and we made it clear that we are the Aborigines, Aboriginal people of this land and of the soil. And as of today, we have declared ourselves free. We will be having a sit down, as Kuse Sabines just said, tomorrow, but it is clear, we made it clear that we are a free people. We are no longer part of the system. We refuse to submit and to compromise. No more, no longer. Self-determination is inevitable. As of today, we are self-determined, a self-determined nation. Kaise Gangans, thank you very much.
Thank you.